prosecution wants some clarification there. Let's bring back Michael Jaafar.
So you brought in the big guns,
Yes.
big guns, Ted, and I like it
That's
a lot.
right.
So you know, for me, seeing this part of the cross-examination, I always ask myself, what is this person getting to? What is his conclusion? What's he going at? I come into it with knowing that he wrote a letter to the judge telling the judge that he thought that the judge is part of a criminal mastermind. I see him cross-examining and belaboring a point to this investigator about why was the search warrant executed in the following manner, right? We all know that they did the right job in executing that search warrant. So what is his conclusion? What is he getting at? And I'm just brought back into the dozens upon dozens of cases when I was a public defender where people just like him wanted to defend themselves and did not take good advice from their attorneys and wanted to pursue paths that were going to hurt them. And it almost always led into the same ditch, which is confusing the jury, going on tangents that were irrelevant, and then hurting their case. I do agree with you, Marie Pereira, that the prosecution should have followed up on the car more so, but his angle here is that they should have been looking at another lady. Well, that's not really defending yourself. Many witnesses have tied him to the crime. Many witnesses, the getaway driver tied him to the crime. The victim tied him to the crime. And there's so much evidence that ties him to the crime, but he's not dissuading that. He's just going down a tangent to kind of deflect attention from himself. In my opinion, as a defense attorney, I just don't think that that's going to lead to an acquittal for him. Just so far, we will see how it plays out. But I do agree with you, Marie. The prosecution could have done a better job. Their case may be a train wreck, but you and I both know, you are an amazing prosecutor, that many prosecutors will rescue a case midway, but defense attorneys can kind of rescue a defense midway. I don't think he's doing that for himself. Let me respond. You know what? I agree. I agree with Marie. Here's what I think is happening. You know what? I put it together. Marie's right that the prosecution could have done a better job. You know what I think is happening? I don't think the prosecution, and I'm guessing here, I don't think the prosecution thought that this trial would get national attention. They saw that this man had fired his attorney. They were trying to plea out the case. They wanted to play out the case because the investigation was done in a little bit of a roughshod manner, as Marie is saying. So I think that they didn't put their A game in, and I don't think they had their A prosecutors, and all of a sudden this thing got national attention. When a prosecutor hears that this person is going to defend themselves, I've been in those rooms, by the way. It's the defense attorney will tell the prosecutor, I just got fired. And then the judge will groan and say, now this person is going to defend themselves. Everybody in the system knows what it means when a defendant defends themselves. Believe me, I've been in those rooms. So I think they did not put on their A game, and I think that they did not expect him to have as much piss and vinegar in him as he does, right? And that's what Marie is bringing up, that he's actually putting up a fight, and I don't think they expected it, and now they're midway through the ball game. It's like when an airplane is taking off and it reaches a speed that it cannot safely abandon takeoff. I forget what the name of what the airline industry thing is, but it can no longer safely abandon a takeoff. That's where this case reached until the prosecution realized, oh, wow, wait a minute. This is going to be watched by millions of people, and we haven't really prepped it right. So that's what I think is happening. I still believe that we're going to see a conviction. I think the evidence against him is overwhelming, and I think he's doing a good job at distracting the attention of the jurors. But I still think that the evidence against him is overwhelming. But I do agree with Marie's analysis. I'm interested to see how this thing concludes. I'm going to bet Marie a coffee over she's been right before, so.
Michael said it again. Marie was right. Let's bring back Michael Jaafar as we wait for court to resume. The technical gremlins are pretty much part of every courthouse, every courtroom, and every lawyer has to deal with it. And now he has this. There's a good chance he's not going to get this thing to work, because we've seen it happen a lot. Bottom line is, he's doing a good job, right? But it's not as good a job as the public defender would have done, is what the only argument I'd make. Oh, you're on mute, Michael.
I'm sorry, Ted.
No problem.
I apologize. Yeah, I was on mute. Here's my opinion, right? you know, there are some terrible public defenders. Is it possible to defend yourself in a trial better than a public defender? I mean, there's pros and cons, right? You bring the passion and the emotion and the understanding of the facts better than any public defender would. But at the same time, you're biased. You're not going to see things like an objective person. Like if somebody were to get through to this person, they would convince him to not do a lot of the things he's doing, right? Some of the things he's doing are well. Marie Pereira brought up an example of something that he did that was well, right? You know, in my opinion, what's the purpose of a trial? The purpose of a trial, if you're a defendant, is to get an acquittal. It's not to expose you know, bad things in the prosecution and then get convicted. You're just delaying your conviction by an hour, right? The purpose is to get an acquittal. So I think he's doing a serviceable job, but I think a public defender would have done a better job. And the evidence of that is that he fired his attorney. He fired his attorney and wouldn't take another one. I've seen this too many times, and it always comes down to the same point. The defendant is not listening to reason. And he said in his letter to the judge, I don't want to take a plea, right? That means they offered him a plea. This is a person where an objective observer would have told him, look, you need to take a plea here, right? I've had many instances where I would line up a really good plea. Most people don't go to trial. Most of these criminal cases, they settle in a plea because the evidence is overwhelming, and you have to overcome a mountain of evidence against you, and the state has been preparing for the case longer than you've been preparing for your defense, right? That doesn't make it right. That's just the way it is.
His plea is time served. I mean, he would have been, he said no to it. And on some level, you're like, all right, well, I guess this guy's doesn't want to be, you know, convicted of something he didn't do.
Yeah,
admirable.
But a public defender would have been able to talk reason into this person, or been able to handle the trial in a better way, because he could have had these same defenses if he had a public defender. It's not like the public defender would have told him, no, this is a good line of inquiry, but I'm not going to do it. The public defender would have done it. And it's a little bit disorienting as well to see a person defend themselves. It's actually, this is the positive side of defending yourself. People see you're sophisticated, you're out there, you're fighting for yourself. But there's going to come a point in this case where there's going to be eyewitness testimony of people that are credible, that saw him, that point him to the scene of the crime. And I just don't see how he's going to do that. What's he going to do? Come back and say, well, why didn't they look at this other lady? That's really his defense, and that's not really a defense. That's a defense if nobody can point a finger to you doing the crime. That's a great defense. They teach us that in first-year law school, right?
Michael, would you, if you're prosecuting here, try to poke the bear a little bit and see if you could get him to explode in front of the jury?
I hadn't thought about that till you brought it up, Ted. That's actually not a bad idea. Yeah, if I was the prosecutor, I know that I have a person who's sober now, but has substance abuse issues, and he's been volatile. And even the judge told him, look, you know, judges and lawyers were a little bit more nuanced than you. We know the courtroom. So yeah, actually, that might not be a bad idea. And at the end of the day, you know, once the finger gets pointed at him, especially by the getaway driver, and that testimony comes up as credible, I'm really interested in seeing his demeanor then, right? Maybe that's when he will explode and become volatile. But I agree with you. If the prosecutor can touch a nerve and get him off in front of the jury, because think about it, if he does, that was outside of the presence of the jury, but if it was in the presence of the jury, and the whole point is this person stabbed a woman to death, they could see that. They could make the connection that this is this type of person, you know, he's very volatile. So yeah, if I was a prosecutor, I would want the jury to see him being very volatile. I agree with you. That's actually a pretty good strategy. Maybe the prosecutor should listen to this broadcast and take that advice, because actually I think that would be a big thing. By the way, not the same thing, but the Ted Bundy trials. That's one of the tips that the prosecutors did. Again, this guy's not Ted Bundy, but that's actually a tactic.
Yeah, to just let them hang themselves with a long enough rope, and give them that opportunity through frustration, because it is frustrating. You know, you see, and the other part of the equation is you want that passion, you want the that emotion, but you want it from the lawyer so that it isn't, you don't make as a juror that connection like, oh, that guy's a little crazy. He might have done it.
Yeah.
When it's the lawyer who's upset, then it's more like, oh, that lawyer's upset. This might be something to do this. So that's a fine line that he's trying to walk, and it's a difficult one. All right, we need a break. Top of the hour. Michael, thank you as always for joining us. Appreciate